Hello, I'm Arizona Lawyer Julie LaBenz. Thank you so much for watching this video. And if you like this video, make sure to like, share, and subscribe so you don't miss any of the valuable teachings that I'm going to share with you. If you are representing yourself in family court, it can be very confusing to figure out what is the evidence that you should be presenting to the court. Now, when I talk about evidence, can be documents to show the court. This can be videos. This can be audios. And this is also your testimony. A lot of self-represented parties get confused because they think that their words alone are not enough. But the reality is that what you testify to, what you say when it's your turn to take the stand, or what your witnesses say, if you call any other witnesses to the stand, that is also evidence. So even if you don't have a document to back up what you're saying, realize that your testimony is still evidence. Okay. So don't feel like you can't present something just because you don't have a document to back it up. Now, if you do have a document to back it up, that obviously can make that evidence even stronger. But I've found that sometimes self-represented parties will self-censor and they won't present particular evidence because they don't think that their words are enough when their words may be enough. So just keep that in mind, number one. All right, so today we're going to talk about what is your best evidence in family court. And of course, this is a case-by-case question because the best evidence isn't the same in every case, but I'm going to give you a framework to utilize to determine what your best evidence is. And that framework is to figure out, what are you trying to prove? So if, for example, parenting time is an issue in your case, then what is the parenting plan you want the court to adopt? And why is that in your children's best interests? Your evidence should be directly related to those points. So, for example, your proposed parenting schedule, that would be a great exhibit to present to show your year-long proposed parenting plan. And once you've had that admitted into evidence, then you can talk about why that particular plan is best for your children. And you'll want to look at the best interests of the child standards in your state, because that is going to be what you're going to want to frame your evidence around. So in Arizona, which is where I'm licensed to practice law, we have a statute. It's Arizona Revised Statutes, so ARS 25-403. And 25-403 has, I believe, 11 different factors for the court to consider. Realize that not every factor is going to apply in your case. You'll want to look through those factors and select the ones that do apply in your case. But let's look at just the first factor. And I'll be honest with you, these factors are a bit strange. It's not that they're not important or that, the law wasn't created in the right way. It's more just that when you read them, they're kind of confusing as to what exact evidence to present related to each one. So realize that they can be a bit awkward, but that isn't of your concern. What your concern is to provide the judge with evidence about the factors that apply in your case, because that is what the judge has been tasked with utilizing to determine what's in the best interest of the children, and then to determine the issues of legal decision-making and parenting time. So the first factor in Arizona's best interest of the child factors is the past, present, and potential future relationship between the child and each parent. Now, I like to break this down into each part because, as you can tell, there's a lot involved in that first factor. So I like to break it down into each part. So number one, what is the past relationship between the children and mom? What's the past relationship between the children and dad? Next, what's the present relationship between the children and mom? What's the present relationship between the children and dad? And then the final part, what is the potential future relationship between the children and mom and the children and dad? So evidence will be presented. And again, this can just be through your testimony. You can potentially have exhibits as well to support the evidence you're presenting, but you're going to go through each of those factors. Now, you want to give the judge concrete details. You don't just want to say, oh, I've always had a great relationship with my daughter. That doesn't tell the judge anything. You want to talk about, oh, I've been an integral part of my daughter's life since she was born. I was the primary caregiver for my daughter. I taught her how to play softball. I taught her how to read. Like you want to get into concrete things, like what is your actual relationship like in the past, the present? And then when we talk about potential future relationship, you're really looking at, like, if you get the parenting plan that you're asking for, how is that going to impact your relationship with your child versus what does your relationship look like with your child if the opposing party's parenting plan is awarded? So think about things in those terms. And again, just you testifying about them is enough. If you have documents that back up what you're saying, great. If you don't, that's okay. You can still talk about these things. Now, let's look at evidence for financial issues. And financial issues can come up related to child support, if you're in a divorce, related to spousal maintenance, related to property division, and then also in terms of attorney's fees. Now, you may not have an attorney, but the other side could be making a request for attorney's fees, or you may be in a position where you previously had an attorney and you ran out of money. You had to let that attorney go, and now you're representing yourself for the balance of your case. And you could be asking that the other side pay for the attorney's fees that you incurred while you had an attorney. So under, the various circumstances, attorney's fees can come into place. And in Arizona, there's 2 factors related to attorney's fees under the law. The law is ARS 25-324. The first factor is the financial resources of each party. And the second factor is the reasonableness of positions adopted throughout the case. So if you have financial issues in your case, often one piece of evidence that can be your best evidence is your affidavit of financial information. In your affidavit, it's showing what your gross income is, and your gross income is relevant to child support. It's relevant to spousal maintenance, again, if that's an issue in your case, and it's also relevant to attorney's fees, as that's a financial resource. So the AFI can be a great piece of evidence. The AFI also documents expenses. So expenses aren't a part of child support, except in very limited ways. The child support calculator, at least in Arizona, takes into consideration the amount paid for health insurance for the children. It can also take into account any special expenses related to a gifted or a handicapped child or a child with any sort of disabilities. And those may be in your AFI detailed out. So you can, use your AFI as an exhibit and go through those particular expenses in your AFI. Now, expenses aside from child support can be relevant to spousal maintenance, proving that you qualify, because in Arizona, one of the ways to qualify is to show that your expenses exceed your income. So you can show that with your AFI. And then also expenses can be relevant to an attorney's fees request to show that you have lower financial resources, because although you have a certain income, you have certain expenses to pay. Okay, so for financial issues, your AFI, depending on what you're trying to prove, can be a great piece of evidence. And then you'll want to go through each element, each piece of property, for example, if you're in a divorce, that's at issue. So if you have a vehicle, your best evidence could be the vehicle loan documents, for example, or a title, a Kelley Blue Book valuation. If you have a piece of property that's in dispute in the case, There can be a number of issues in dispute. Is it the value that's in dispute? Is it how it's going to be divided? Is it whether it's going to be sold or awarded to a party? You want to really focus on what exactly is the dispute, and then you want to gather your evidence focused on what that dispute is about and how you prove your side. So this means you need to know, number one, what's at issue, what's in dispute, and what is your requested outcome regarding that dispute. And then you want to tailor your evidence around those issues. Okay? So if you have questions about what I'm talking about, put those questions down in the comments so that I can put a video together to address your questions. Okay? So if you have a question about a particular type of property, if you have a question about parenting time or child support, spousal maintenance, attorney's fees, whatever your issue is, put that down in the comments because I'd love to hear from you. So those are some issues related to property division, and I'll do another video that will explain a really great way for you to get your property division case really dialed in. So stay tuned for that. For spousal maintenance, you first need to show you qualify. So you'll want to present evidence. Again, that evidence could be your testimony showing how you qualify. And the qualifications are based on statute. In Arizona, the statute is ARS 25-319A. That lists out 5 different ways that you can qualify. So you'll first present testimony and evidence about why you qualify. And then you'll want to present a spousal maintenance worksheet detailing out the amount per month that you believe you're entitled to and that you're asking the court to award, and then the duration. How long are you asking that spousal maintenance be ordered for? Now, if you're opposing a spousal maintenance request, your evidence is going to be tailored around why the other side does not qualify. And again, you'll be looking at those qualification factors and arguing about why they don't qualify. And then additionally, about if they do qualify, then what should the amount and duration be? And you can argue that the amount and duration should be 0, again, if you have evidence to support that position. With child support, in addition to your affidavit of financial information, some of your best evidence is going to be your proposed child support worksheet, where you've put forth what each side's gross income is, any particular other factors that apply in the calculation, what the parenting plan is that you've proposed. And then that's going to give you a number, and you'll want to use your child support calculation as your worksheet as one of your exhibits, and then testify to each factor and why you used the numbers that you did in your proposed worksheet. And then for an attorney's fees argument, if you're asking for attorney's fees, again, if maybe you had an attorney in the past, as part of your case, but then had to let them go because you ran out of money to pay them, then you'll want to present evidence on those factors of financial resources of each party and the reasonableness of positions taken throughout the case. Now, reasonableness under Arizona law is generally been described as taking a position that is contrary to law. So, for example, not disclosing evidence that you're required to disclose under Arizona's Rule of Family Law Procedure, Rule 49, ignoring a discovery request, not submitting an AFI, not submitting a proposed child support worksheet, not engaging in settlement negotiations. Like, being unreasonable is not just taking 2 different positions. Like, the law recognizes you're allowed to have opposing positions. You're not required to agree on everything. More what the law is focused on regarding unreasonableness is if you're not following the rules of procedure and the law with how you're conducting your case. So if you're asking for an award of attorney's fees, you'll want to provide evidence regarding those factors. And then also, if you're arguing against the other side's request, you want to present evidence on those factors, but from the perspective of why the other side should not be awarded their attorney's fees. In other words, why you shouldn't pay their attorney's fees. You can talk about your financial resources versus the other side's. And you can also talk about reasonableness of positions taken throughout the case. All right. I hope you found that helpful. Let me know if you have any questions about evidence. Also, I'll make sure that you have a video that comes up at the end of this one to watch another video of mine that explains how to present evidence at trial and get it admitted, like how to present an exhibit and get it admitted into evidence. So I'll make sure that there's a link so that you can watch that video. And be sure to give me a like, be sure to subscribe, and be sure to leave a comment because I'd love to hear from you. And I know that you're feeling alone and lost. It's a very difficult place to be representing yourself. And I'm here as a resource for you. Not that I'm going to be able to answer all of your questions or act as your attorney, because that is not my role. But I am here to educate you and empower you with the information that I'm providing as legal information and education. All right, that's it for today. I'm Arizona Lawyer Julie LaBenz. Thank you so much for watching. And I look forward to reading your comments. Bye.